The Payment of Wages Act 1936 and Minimum Wages Act. My name is K. Umesh Rao. This subject is covered under Labor Law 2. In this class, we are discussing classification of wages, Payment of Wages Act 1936, Minimum Wages Act 1948, and deduction from wages, authorized deductions and unauthorized deductions. Classification of wages. Wages are classified into four categories. One, living wage. Second, fair wage. Third, minimum wage. Fourth, subsistence wage. What is the living wage? It stands for highest standard of wages. Living wage, it includes better standard of life, better standard of food, clothing, residence, and also money, surplus money available for children's education, protection against ill health, and requirement of all essential social needs, and measure of insurance against old age and accidents. The framers of the Constitution wanted to provide a decent standard of life, full enjoyment of leisure, social and cultural opportunities, and good conditions of work throughout the country by providing living wage. Second one is fair wage. What is the fair wage? Fair wage, it stands between the living wage and the minimum wage. It is more than the minimum wage, less than the living wage. It must be paid according to the financial position of the employer, financial capacity of the employer, and efficiency of the worker and his needs for his family. What is the fair wage? Wage, it is fixed by collective bargaining is the minimum wage. Whenever the capacity of the industry to pay higher wages is established, such higher wages should be treated as fair wages. Minimum wages. Minimum wage is the starting point of the wage policy. It is the lowest standard of payment when compared to living wage and fair wage. The Minimum Wages Act 1948 does not define what is the minimum wages. It is not possible to bring down a uniform minimum wages for all the industries throughout the country. Government empowered to fix minimum rates of wages for different employments, different classes of work and different locations. Government can fix different minimum wages for adults, for children, for adolescents. Minimum wage it should satisfy the needs like food, clothes and shelter. Another term is subsistence wage. It differs from statutory minimum wage. It is lesser than the minimum wage. Subsistence wage is sufficient to meet only the bare necessity of the worker and his family, his food, clothing only. The statutory minimum wage is higher than the minimum wage is always higher than the subsistence wage. Supreme Court said that an employer who could not pay the subsistence wage is not entitled to exist in the field. The court said whether the industry has paying capacity or not, it must pay the minimum wages fixed by the states. Now we are discussing with the Wages Act 1936. What is the object of the Wages Act 1936? Wages Act 1936 is to pay the wages to all the employees. When the pay the wages at the proper time and the specified in the act, and it prevents unauthorized deductions. As per this act, every employer shall be responsible for the payment of wages to the persons employed by him. Employer shall be liable to pay the wages for the periods in respect of which such wages shall be payable. Wages shall be paid in coins or currency notes or both. The Act imposes penalty on the employer who willfully delays the payment of wages within the specified time. Employers shall be punishable with a fine of ₹1,500 and fine may be extended to 7,500. So, what is the right to the employee? Employees have the right to receive the wages at proper times without unauthorized deductions. Now we are discussing the meaning of the wages. What is the wages? Wages means all remuneration, allowances in terms of money payable to persons in respect of his employment. It is a broad definition. So wages include any remuneration payable under the settlement between the parties, settlement between the employer and employee, any remuneration entitled in respect of overtime work or holidays or leave period, any additional remuneration payable in terms of employment called bonus also, any sum which by reason of the termination of employment of the person employed is payable under this rule. But wages does not include, what is that? Any bonus which does not form part of the remuneration payable under the terms of the employment. Value of any house accommodation, supply of light, water, medical attendance, contribution paid by the employer to any pension, provident fund, any traveling allowances, some paid to the employed person, any gratuity payable on the termination of employment. These are all doesn't include in the wages. Next term we are discussing is Minimum Wages Act 1948. The Act provides that any minimum rate of wages is fixed by the government in respect of employment. Minimum wages shall be paid in cash. If any worker makes any contract with the employer and he makes a contract to receive less than the minimum wages, then such contract is void. It is called contracting out. Now, deduction from wages. What is the deduction from wages? What is the meaning of deductions? Deductions means payment made by the employed person or employee to the employer or his agent. It is treated as deemed deductions. Any payment made by the employee to the employer is deductions. But following are not deductions. Which one? Withholding of increment or promotion, stoppage of increment, reduction to lower post or lower stage, suspension of an employee. What is the permissible deductions from wages? It is the authorized deduction from wages. Wages Act 1936 was introduced to regulate the deductions and prevent the unauthorized deductions. So, the list of authorized deductions. What are the authorized deductions? First, employer can deduct from wages what? Fines. Employer can deduct from wages deduction for absence of duty and deduction for damages to goods or loss of goods and deductions for recovery of loans. These are all the authorized deductions or permissible deductions. So, in other words, authorized deduction is classified into categories. Fine imposed for, why fine is imposed? It is for disciplinary purposes, to bring discipline in the establishment. Damages means employee causes any damages to the material intentionally or negligently and causes loss to the employer. Such damages may be recoverable from the employee and benefits given to the employee. Employee takes loans, advances from employer for the purpose of house construction. Employees take loan from cooperative societies. Employees have to pay LIC premium. All these categories are recoverable from the wages. Now let us discuss what is the fine. Fine are imposed on disciplinary reason. The before introduction of the Wages Act of 1936, employers are imposing fines on employee according to his will and fancy without any reasonable manners. This act imposes certain restrictions. After the introduction of this act, it act imposes certain restrictions upon the employer. It removes employers' power to impose fine arbitrarily. The act permits the employer to put fines and deduct fines from wages for the maintenance of only discipline. What are all the restrictions imposed upon the employer regarding the imposition of fines? No fine shall be imposed on an employed person without the previous approval of the state government or the prescribed authority. Employers must exhibit in a notice specifying such acts and omission on the part of the employment. The object of the notice is to educate the employee. Total amount of the fine shall not exceed 3% of the rupees of the wages. No fine shall be imposed on any employed person who is under the age of 15 years. Employer has to record all the fines in a register of fines as prescribed by the state government. The amount deducted as fines and accumulated shall be applied only to the beneficial purposes of the employees of the establishment. Now, authorized deductions, we will discuss this. What is the authorized deductions? Deductions for absence from duty, deductions for damages to the goods or loss of money, deduction towards house accommodation, amenity and services, deduction towards recovery of advances, deduction for recovery of loans made from any fund for the welfare of the labor, deduction for income tax payable by the employed person, deduction for payment of cooperative societies, deduction for payment of LIC premium, subscription to welfare schemes, subscription to trade unions, contribution to the National Defence Fund, deduction for recovery of losses by railway, deduction by the order of the court, deduction with the consent of the employee, deduction of professional tax. All these are authorized deductions. Now we will discuss one by one in detail. Deductions for the absence from duty is permissible deduction. It is the employee voluntarily absent from duty due to any circumstances. It does not include forced absence of employee. What is the forced absence of employee? Forced means employer asking the employee go on leave. So then employee is forced to go on leave. So what is the restrictions in this case? Deductions may be made only on account of the absence of an employee from the place where he is required to work as per the terms of the employment. Such deduction shall not made a larger proportion than the period for which he was absent. Now some case laws are there. Bank employees demanded wage revision. Bank employees decided to go on strike for 4 hours daily. Bank issued circular to deduct full day's wages by issuing circular. They went on strike for 4 hours daily, but bank issued a circular to deduct full wages, full day's wages. It is held strikes and demonstrations are legitimate form of protest. Bank cannot ban by issuing a circular. Another example, Railway employee applied for casual leave for participating in agitation. Railway refused to leave. Employees participated in the agitation. Management deducted wages. It is held that participation in an agitation against railway is unauthorized. Now, deduction for damages or loss of goods. So, in this case, some goods are entrusted to the employee for his custody. Goods are damaged because of his negligence. Goods are lost because of his negligence. Then employee is required to account for this loss. Why this deduction is permissible? Because purpose is to prevent the negligence and amount connected will be used for the purpose of purchase of new material and damaged material will be used as a scrap. Restriction. This deduction should not exceed the amount of damages caused to the employer. Employer should follow the principles of natural justice. That means employer has to issue notice. Employer has to grant personal hearing. Then only deductions are permissible. Any such deduction shall be recorded in the register. Now, deduction towards house accommodation, amenity, and services. House accommodation is provided by the employer to the employee. Employer has the right to deduct the amount from the wages. Condition: deduction amount should not exceed the value of house accommodation provided or amenity or services provided to employee. Recovery of advances. Recovery of advances like traveling allowance with the interest. No recovery shall be made for such advance given for traveling allowances. Deduction for recovery of loans made from any fund. Condition: funds constituted for the purpose of the welfare of the labor, for example, loans granted for house building advance. House building advance may be deducted from the salary. Now, deduction from income tax payable by the employed person. Deduction required to be made by the order of the court, the employer to deduct the amount. When there is a court order, employer has to deduct the amount as per the court order. And deducted amount should be paid sent to the court directly or pay the amount to the person directed in the court order. For example, amount payable to the creditor. Court orders maintenance of children, parents of the employees. This is permissible. Payment to cooperative societies. Employees might have taken loan from the cooperative societies. Employer may make deduction for payment of cooperative societies and payment of LIC premium. Employer may make deduction for payment of life insurance policy or government securities. There must be authorization of the employee to deduct such an amount. Subscription to the welfare schemes. Payment of employer's contribution to any fund constituted by the employer or deduction towards trade union registered under trade union for the purpose of welfare of the employed person. What is the condition? There must be written authorization from the employee to deduct. Subscription to trade unions. Employer to make deduction for payment of fees payable by the employees for the membership of any trade unions registered. Condition: employee should give his consent in writing to the employer to pay for the subscription of the trade union. There should be authorization and contribution to the National Defense Fund. Employer may deduct such amount for contributing to the Prime Minister's National Relief Fund. Next one, the deduction for the recovery of the losses of railway. The railway employee, it is concerned with only railway employees. Railway employee accepted counterfeit coins. Railway employee accepted mutilated notes, so forged currency notes, so from the customers. Now employee has to account for it. It is the deduction of recovery of losses sustained by the railway. Another case is the railway employee failed to issue invoices, bills, and collect money, collect charges. Because he has failed to issue invoices, railway incurred losses, so it has to be accounted. Railway employee granted rebate refunds incorrectly and causing loss to the railway department, so it has to be deducted. Railway employee failed to account freight, damage, wharfage in respect of sale of goods. So railway incurred losses because of this conduct of employee, so it has to be accounted. Deduction shall be made giving an employed person an opportunity to show cause against the deductions. Thank you.